Hi everyone. Today I will be talking about the development of the thought for serious inventions of privacy in Australia, a topic that's becoming increasingly important in both our legal system and daily life. Privacy is a major concern in modern society, but Australia's privacy law has long been considered incomplete or outdated. In this presentation, I will walk you through the history of privacy law, introduce the recent 2024 reform, and explain how case law, especially in the water case, is shaping privacy as a common law right. We are seeing more serious privacy breaches than ever before, like posting someone's intimate images online after breakup, or sharing someone's address or phone number without their consent, which we call it doxing. This invention deeply harm a person's dignity, safety, autonomy, or mental health. As a result, there's growing public support for stronger legal protections. Uh, yeah. Australia didn't have any real privacy legislation before the 1980s. Privacy was only indirectly protected by common law areas like trespass and defamation. In 1980, Australia adopted the Organization for Economic Cooperation and Development guidelines on privacy, which helped shape future legislation. Then in 1988, the Privacy Act was passed, but it only applied to federal agencies and a few private bodies. During the 2000s, reforms expanded it to private organizations through the National Privacy Principle. Finally, in 2014, these were replaced by the Australian Privacy Principles, which form the foundation of our current federal framework. Fast towards to November 2024, a major milestone. The Privacy and Other Legislation Amendment Bill was passed. It introduced a new statutory tort for serious invasion of privacy, covering acts like intruding upon someone's seclusion or misusing private information. It also outlines clear defenses such as lawful authority, consent, or journalistic exemption, helping legal professionals know exactly how to advise and act under this law. Interestingly, just 2 weeks before the bill's second reading, a case called Waller vs. Braid made headlines. In that case, Judge Chen went further than before, recognizing privacy as a fundamental common law right, broader than just protecting human dignity. He also introduced a helpful test for future cases. It's a reasonable test. Whether a reasonable person in the claimant's position would find the public disclosure of privacy facts highly offensive. Although he didn't fully define all elements of the tort, this judgment signals a turning point in Australian privacy law. While this new tort is a big step forward, it is not perfect. Legal scholars are already calling for clear definition in the new tort, in the new law, in the new tort law, stronger regulation of emerging technologies like facial recognition and AI, and harmonization between the federal and state privacy laws. However, I believe this reform lays the groundwork for real progress, and we will likely see more important cases and precedents in the next few years. Thank you for listening. I hope this gives you a clear picture of how privacy law is evolving in Australia and why it matters for legal professionals and everyday citizens alike. Thank you.